Law of negligence. Law of negligence. Negligence law is an important concept in civil law that focuses on the responsibility of individuals and organizations to be careful and not harm others. It comes into play when a person fails in their duty of care, endangering or injuring another person. These cases usually involve determining whether the person or the defendant has acted appropriately under the circumstances. Simply, negligence law aims to ensure that everyone takes reasonable steps to prevent harm. If someone does not follow these steps and their actions cause harm, they will be held accountable. Consider this. If you are driving a car, you should be careful not to hit pedestrians or other vehicles. If you cause an accident, this is an example of negligence. Thus, the law of negligence is designed primarily to encourage individuals and organizations to be careful and cautious about the safety and health of others, to be appropriate to prevent unnecessary abuses. The real question in civil cases involving negligence is whether the person accused of negligence did something that put others at risk, and whether they should have done more to prevent that situation from happening. It seems like a way to ensure that people are responsible and don't cause harm through negligence. This principle applies to many situations, such as medical care, accidents, and even manufacturing. Essentials of negligence. Let's discuss the elements of negligence. I. Duty of care. The first element is to establish that the defendant owes a duty of care to the plaintiff, the aggrieved party. This duty is a legal duty not to harm others. The required level of care depends on the circumstances and the relationship between the parties. For example, doctors have a greater responsibility to care for their patients than ordinary persons. 2. Breach of duty. The second element is to determine whether the defendant violated his duty of care. This occurs when the defendant's conduct falls below the due standard of care in the circumstances. Certain acts, omissions, or failure to take reasonable care may constitute criminal offenses. 3. Causation. Causation is evidence that the defendant's crime was the cause of the plaintiff's injury. There are two definitions. Cause and fact. The injury would not have occurred without the defendant's conduct, and proximate cause. The defendant's conduct was found to have caused the injury. 4. Foreseeability. The injuries suffered by the plaintiff must be reasonably foreseeable because of the defendant's actions. If the harm was not reasonably foreseeable, a negligence claim might not be successful. V. Damages. For the negligence claim to succeed, the plaintiff must have suffered injury or damage because of the defendant's wrongful act. Damage can be physical, emotional, or financial loss. 6. Defenses. Defendants may raise a variety of defenses to negligence claims, such as contributory or comparative negligence, where the plaintiff personally caused the injury, perception of risk, the plaintiffs have the knowledge for acceptance of the risk, and other circumstances such as causation, the plaintiff's own actions that caused the injury. Standard of care. The standard of care refers to the level of caution, prudence, and diligence that a reasonable person would exercise in similar circumstances to prevent foreseeable harm to others. The concept of the standard of care is a fundamental element in determining whether a defendant is liable for negligence. The standard of care varies depending on the situation and the relationship between the two parties. It represents the level of care and attention required by a reasonable person in similar circumstances. Example: a doctor is responsible for a higher standard of care due to his/her specialized knowledge and expertise. Types of negligence. The relationship between the parties involved and the specific circumstances. Negligence can be divided into different types. Below are some types of negligence. A. Common negligence. This is the most common form of negligence, where a person fails to exercise reasonable care and causes injury to others. This is a general concept of negligence that applies to everyday situations such as car accidents or hit-and-runs. Example: a driver fails to stop at a red light and collides with another vehicle, causing injuries to the pedestrians. B. Gross negligence. Gross negligence involves much higher carelessness than ordinary negligence. When someone's behavior causes concern for the safety of others, courts will generally take gross negligence more seriously and may impose severer penalties. Example: a lifeguard at a busy pool leaves the post for an extended break without ensuring that another lifeguard is present, resulting in a drowning incident. C. Comparative negligence. Comparative negligence occurs when both the plaintiff and the defendant have some degree of negligence regarding the damage that occurred. The court takes into account the fault of both parties and adjusts the compensation accordingly. Example: a pedestrian jaywalks across a busy street and is hit by a speeding car. The court determines that the pedestrian is 30% at fault and the driver is 70% at fault. D. Contributory negligence. This is a stricter form of comparative negligence. In a negligent judgment, if the plaintiff is found to have harmed himself in any way, the defendant will usually be prevented from receiving compensation even if he is guilty. Example: a person slips and falls on a wet floor in a store, but was wearing inappropriate footwear for the weather conditions. The court might apply contributory negligence. E. Vicarious liability or vicarious intervention. This type of negligence makes the employer or supervisor liable for the actions of its employees or agents that occur at or near the workplace. For example, if an injury occurs while the employee is performing job duties, the employer may also be liable for the injuries. Example: an employer may be held liable for a delivery driver's negligence while driving a company vehicle during work hours. F. Professional negligence, malpractice. Professional negligence, also known as malpractice, refers to the negligence of professionals such as doctors, lawyers, or accountants while performing professional work. They are expected to meet a higher standard of care due to their skills and knowledge. Example: a surgeon leaves a surgical instrument inside a patient, causing complications after the surgery. G. False misrepresentation. This type of negligence occurs when a person provides false information to another party, and that party suffers harm because of reliance on that information. Example: a company providing inaccurate financial information to investors may result in financial loss. H. Negligent infliction of emotional distress, NID. NID occurs when someone's negligent actions cause severe emotional distress to another person. Example: a store employee falsely accuses a customer of theft, resulting in the customer experiencing severe emotional distress. I. Residential ipsa loquitur, the thing speaks for itself. Residential ipsa loquitur is a legal doctrine that allows a plaintiff to establish a presumption of negligence when an accident or injury wouldn't have occurred without someone's negligence. Example: a surgical tool is left inside a patient's body after surgery, and it's clear that such an incident would not occur without negligence. J. Premises liability. Premises liability involves negligence related to unsafe conditions on someone's property, and property owners may be held liable for injuries that occur on their premises. Example: a store owner fails to fix a broken step, and a customer trips and falls, suffering injuries. K. Statutory negligence. Statutory negligence involves a violation of a statute or regulation that leads to harm. Example: a business owner violates fire safety codes, leading to injuries when a fire breaks out on the premises.